Now, you know that some petitions have been taken to the presidency and were subsequently forwarded to the Chief Justice, and now we hear that the Chief Justice has made what is known as a prima facie determination, meaning by her first impressions of the documents, the people who are accused of some wrongdoing have questions to answer, and therefore a committee has been set up to probe these. Who are they? They are the Electoral Commission chairperson, and there are two other deputy commissioners, Georgina Owusu-Amankwa and Amadou Sule. So the process is about to start, or has started, but there are issues that are rising as a result. So can we now look at those matters that have come up? And who do I start with? I think I would start with Ejapa. What's your reading of all that is going on? And thank you very much indeed for your time, because we know you're supposed to be in Kumasi, and you made time to come to be with us here. Unfortunately, you are in Kumasi doing things that some of us feel is very terrible, that you, the party that promulgated the law that is supposed to allow dual citizens and citizens abroad to vote and vote from abroad, you are the ones going there to disallow your dual nationals from holding executive positions.
Inaccurate.
This is an ambush.
It's very accurate.
No, it's not. It's not the party. It's members of the party who have a right under the Constitution to make proposals
for amendment.
Absolutely, who have done so. So it is for the party to accept or reject those proposals. And that's what's going to happen. Yes, I disagree with the proposal, but the members who proposed it have a right to do so.
Okay.
And it is not for the party secretariat to reject proposals that come from members of the party.
Any proposal at all you take?
Any proposal that comes, yes. We believe that the delegates of our party have what it takes to decipher whatever the objectives that are being submitted are, and to take a decision. Of course, I mean, it would be in line with what the Constitution is.
Right.
I mean,
well,
I'm not sure anybody can bring a proposal that make my wife, for instance, something.
Well, they've had a press conference. They have issued a statement. The aspirants have issued a
good
statement,
advocacy.
And they are telling you that, and they are telling you that, look, already the Constitution of Ghana gives us a lot of pain, because we have been excluded from holding certain public positions, and now you want to add this, that we can't hold a position in the party. That's wrong. So pay attention to Professor Stephen Kwekwasare's, proposal, asking the government to rather, scrap the exclusion list. Because you are a dual citizen, you can't be secretary to the cabinet. You are a dual citizen, you can't be this, you can't do that. Rather take that one away and allow our citizens, brains, develop a nation, like the president said.
Well, when we get there, we'll cross the bridge in respect of the national constitution. But for the issues that you're raising regarding the proposals, I think it's good advocacy. It's useful for them to air their views so that the people who take the decision can evaluate the pros and cons of what the proposers are saying and what it is that the people who will be affected are saying.
Okay.
But my challenge with the press conference is sort to create the impression that this is something that the party wants to do. And I'm saying that is incorrect. The party hasn't taken any decision either to accept or reject this proposal. They are members of the party, are entitled per our constitution to make proposals.
Well, who knows if they have not spoken up? If they are not spoken up, this amendment may have carried.
That's what I'm saying, that it's good advocacy for them to.
When you are going for elections, you need their money. You go for the money, and then they want to take part in the process, and you want to kick them out.
Like I said, speaking for myself, I do not agree with the proposals that were submitted by whoever the proposers are.
Okay.
And so when I go, I'll vote.
Okay. And you say you are rejecting it.
Of course.
Okay.
And I'm sure that proposal, when it comes to law, it will be debated. And would evaluate those who are in favor and those who are against and take a decision.
Right.
And I'm not sure it will carry.
Okay.
And I agree with the foreign branches for the advocacy that they sought to carry out by their press conference. It's useful for those many people who probably have not adverted their minds to the key issues to now apprise themselves properly of what it is that the issues are about and to enable them to take a much more informed decision.
Okay.
But it wasn't the party. And that sense of attacking the party that, you when
say it
you need
wasn't
our
the
money,
party,
you
but there
come
were claims.
for our money
There were
and
claims.
all that.
There were
thought it was
claims. And let me
unfortunate.
bring Abuchi in on this for a minute. There were claims that the party was introducing this amendment to disallow members who have dual citizenship from holding party offices so that their constitution can be brought into conformity with the national constitution. And some said that is false because the national constitution does not prohibit them from holding every position. It's just some positions.
But Samson, not to interject, but that premise is...
No, I asked him that...
The party hasn't made any proposal.
That proposition was on radio. People were talking about it.
That's why we're here to correct
desire.
that impression.
Okay.
Because it's completely flawed.
You agree?
Well, it's fair to take him at his word, and indeed the party at its word, because if you haven't cited an official communication from the party, then we can, on the face of it, suppose that the party hasn't taken an official position. People can make all kinds of speculations and say all kinds of things, but parties have ways of communicating, and there are designated officers of the party who speak for the party. If these people haven't spoken and there is no official communication, we can all assume that the party hasn't taken a position on that. But again, the Constitution of Ghana specifically states that political parties shall be organized along democratic lines.
Right.
But these democratic lines invariably must also take account of our overall laws.
Right.
If the party therefore wants to synchronize its internal laws with the Constitution of Ghana, nothing stops it from doing that. And you're right, that not all positions in Ghana, it's not in respect of all positions in Ghana that public positions in Ghana that the diasporans are disbarred from taking. There are specific positions. So the question is, even if the party actually decides to do that, whether it will have to restrict itself to those positions for purposes of synchronizing it with the Constitution. My argument is, at this stage, we may be conjecturing things, but if the party decides to do that, it will have to obviously ensure that they are in sync with each other. But ultimately, the party has the right to take decisions for its own internal runnings, to the extent that these are not incompatible with core democratic principles as Article 55 or so of the Constitution.
Thank you.
So let me just add that in the discussions that are taking place, let's distinguish between dual nationals and Ghanaians resident abroad. A diasporan is a Ghanaian resident abroad. A diasporan could be fully Ghanaian,
Right.
but resident abroad. And then you could also have a diasporan who is a dual national. But you could also have somebody resident in Ghana who is also a dual national. So I just wanted to have that.
That's true. Okay, thank you. So on the petitions and matters arising, petition against Charlotte Osei and petition against the two other deputies and the matters arising, what do you say?
Well, it's unfortunate once again that we politicizing the entire debate, because I thought that the issues were clear enough. Pre-election rhetoric notwithstanding, this is a petition that had been submitted by citizens of this country in accordance with the Constitution. Persons who have sworn an oath to defend and abide by the Constitution are enjoined to act in accordance with that very document. And so His Excellency the President does what is required of him on Article 146 and submits the petition to the Chief Justice. Couple of months down the line, she adopting whatever process that in her wisdom was appropriate to enable her arrive at that determination of a prima facie case to be answered. Now comes to say that, look, these persons ought to answer. And so I have set a committee to investigate the matter in accordance with the Constitution. And hell breaks loose. That the agenda of the government to remove these persons from office is what has been triggered. Makes you wonder where they were between July and November. Well, in this country, nobody spoke. Of course, initially when the petition came, the Electoral Commissioner herself, unfortunately, if you ask me, played the whole issue in the public domain by responding to the issues that had been raised and all that, made counter accusations against.
She did in public?
The letters that we all saw.
Okay, so you mean letters that were leaked?
Yes.
Okay.
As to whether they were leaked by who, I am not in a position to tell. But we saw the responses. And she made counter accusations against her 2 deputies. So I asked myself, so in the midst of all the issues that were being thrown out there, what was it that anybody supposed to do? Because the NPP or some, so far I haven't heard anybody pinpoint a particular high-ranking member of the party who said that the woman was going to be removed at all cost. Assuming that those statements were even made. And so we should gloss over it because some political opponents were going to raise issues. In any event, why is the Electoral Commissioner herself going through the due process, yet others have an issue? What is the interest that they have in this matter such that they make threats that Ghana is going to burn if due process is followed? If we don't believe in the Constitution that we are practicing, let's say so and find alternative means of governing ourselves. But until and unless we do that, please, let's do things devoid of politics and abide by the rule of law that we also claim to believe in so much. And let the process take its course. After all, Mrs. Osei has not been pronounced guilty. Nothing has been established against her.
Oh, something has.
What is it?
When a prima facie has been made, it means that on the face, if you don't come to answer,
absolutely,
you are guilty.
Yes.
Unless you come and overturn it.
Of course.
Right.
And so she has the avenue to do that. Okay, so no guilt has been pronounced as we speak.
That's right.
Okay, so let the process take its course.
But there are questions being asked. For example, we now know that the committee has been set up in accordance with the Constitution. Supreme Court Justice Benin is the chairperson. Justice Mafosa of the Court of Appeal is a member. Justice Doji is a member. Welbeck Abra Apia is the non-lawyer, non-MP, and Council of State nominee or member. And then there's supposed to be one other female who has not been named. People are raising issues about that. Why would she not be named? Because she ought to be known. And the EC has actually, EC chairperson has actually written seeking to know the membership. But the question that also follows is that we understand that out of the 25, 27 allegations against the prima facie has been made on only 6 of them. The question is, was it really worth it? Because you have as many as 25 something.
So, Samson, let me ask you a question, even though you are the host. So, if all 27 out of the 27, only one was found to have been worthy of some investigation, would you say that it was not worth it? Let's not, you know, of course I know you are not trivializing the issue, but the point of the matter is this, that people can make all sorts of allegations against you. And that is precisely the reason why the Constitution makes provision for some meaningful basis for an investigation to be conducted. So it doesn't matter whether 6, 7, or even 1 allegation was found to have been worthy of investigation. That is what has to happen. And I do not have an issue with the procedure and the letters that she's written.
Right.
My only worry
to the presidency
was
and to the
why
Chief
directed
Justice.
to the presidency. I thought that, particularly because she's represented by counsel, and knowing very well that this petition, when it goes to the president, his only role is to, as it were, because several communication come to his office, he needs to know that, well, the content of this relates to an impeachment request. And so he forwards it to the appropriate body, in this case, the Chief Justice.
To keep a file, though.
Well, keep a file, I'm not so sure. And
well,
of course, I did not work in the presidency.
The spokesperson for the presidency has confirmed that they could never have forwarded it without keeping a file. So they have a copy.
Well, they have a copy.
Yeah, except that they feel that you can't ask us for it.
Absolutely. And you see, I even thought that it was premature, because if you attend the committee hearing, which essentially is supposed to be an in-camera proceeding, whatever documentation that you require, you can request for same to be made available to you to enable you to respond appropriately. Okay. So writing letters and keeping the thing in the public domain, I don't get it. But, well, that's maybe the way they've chosen to deal with this constitutional matter. Okay. And I would only urge that to the extent that we all want a peaceful country, I mean, I've said that pre-election rhetoric, everybody heard what they wanted to hear, or read into what they wanted to read. I was looking at this entire process of her appointment in a completely different light. Because, to my mind, if she was the head of the National Commission for Civic Education, terms and conditions of which are the same as that of the Electoral Commissioner and the Commissioner for Human Rights and Administrative Justice, and those offices are protected under the Constitution, was her movement from NCC to Electoral Commission a transfer? And could the president do that? Could she resign from the same salary and go to take the same salary in another job? Those were the questions that engaged my mind.
And you had an answer. Yes, we debated it, but you had an answer. Your answer was that it was a wrong process.
Absolutely. You understand? So, well, we're where we are. And she's a very fine woman. You know, I don't know her personally, but I guess that largely the electoral commissioners have brought this upon themselves. And regardless of the comment that whoever made, I think that due process ought to be carried through.
Okay.
And the logical conclusion reached in respect of this matter.
Yes, Mawayaga.
Well,
the matters arising from the petitions and the prima facie determination that's been made.
I mean, there are dangers involved sometimes in these discussions when a matter is being investigated and you also sit on radio or on television and begin a process of public trial. There are all sort of dangers. But at the same time also, the requirements of transparency sometimes may require that we also pay attention to what is happening during the proceedings of these investigative bodies. And the issues of accountability may require that we follow track and see is everything being done according to law. So far, what are the issues? Issues are that some people have petitioned the president regarding the conduct of the chairperson of the Electoral Commission, and in the process, 2 other members of the commission have been roped in. What does the Constitution say? Can people petition? Yes, it says they can petition. Who do they petition? The Constitution says the president. What is the president supposed to do when there's a petition? Constitution says refer it to the Chief Justice. Has he done so? Yes, he has referred it to the Chief Justice. Should he have referred it to the Chief Justice? Tell me if he had an option. So if he doesn't have an option and he refers it to the Chief Justice, no wrong committed.
Well, Akufo-Addo suggests that he could have an option because in his time working with the President Mills, there were petitions that came in and you decide what to forward and what not to forward or ignore, because there's a political questioning around some of these things and you need to exercise a certain judgment.
Yes, indeed. I was going to get to that. We all know how, those of us who have been in government, and I have worked at the presidency, I've worked in ministries and in parliament and etc. Those of us who know how this country works knows that the facade of not having a discretion, really, people like us don't get deceived by that. Legally, the president has done nothing wrong. So if you're asking me my opinion here, I would say the president has done nothing wrong. He's acted according to the Constitution. Okay. But if you ask me as a politician, what do I think? I would say the president has ways of making sure that no petition is generated at all. And the president has ways of making sure...
By acting unconstitutionally, you mean?
Not acting unconstitutionally.
Good question.
Not acting unconstitutionally. That's why I said that.
In President Mahama's time too, we became aware, it became public knowledge that actually there had been an earlier petition sent against Madame Charlotte Osei about allegations of including conflict of interest when she was NCC chair and was on the Ghana Reinsurance Board, and when she went to the EC and was still there and so on and so forth. But the president never found it necessary to forward it.
Well, I mean, I don't have those...
they are public facts.
Records.
You can go ahead.
Yeah. I don't have those records. Yeah. It's not everything public that I have access to. It could be
convenient. Please go ahead.
Not conveniently.
I know what you're doing, but go ahead.
No, I'm not doing anything.
You were saying that the president hasn't done anything wrong by forwarding it. Akufo-Addo says that, look, if it's not because he knew of this political hounding of this woman, you know, he should have just kept it or ignored it.
Well, I mean, the point that I'm making is that presidents running countries have ways of getting things done. And so if you ask me politically whether there was another way of handling this, I believe that if a president wants to handle it in another way, and Koku is recounting his experience as he indicated, working with late President Atta Mills, and I also worked closely with late President Atta Mills. And what was the history? The history is usually what guides your conduct as a president. Of course, you're also supposed to be guided by the law and the Constitution, but you are running a country. In the case of what Koku is talking about, yes, there were petitioners, but what did the president do? Rather, you talk the petitioners out of their petition. I mean, maybe that is what he did. And maybe it was because before NDC assumed office, there was all sort of perception that the NDC would go after the then Chief Justice, George Wood. Now, if indeed NDC won elections and came into office, and indeed anybody went after the Chief Justice, and the then president did not protect the Chief Justice in any way, people will conclude that their prediction that if NDC won, they will go after the Chief Justice is being borne out. Now, a similar history, where at the point when this woman was being nominated, we heard all sort of things from leading members of the NPP. Indeed, I mean, it was public record that a leading member of the MPP said that she traded sex for this position. And there were all sorts of threats that she would use her position to influence the elections in favor of John Dramani Mahama and all sorts of things. Even as we sit here, he is still questioning the appropriateness of her appointment. In fact, that is what he has just done. So with that history and background, when you become president and people petition for the removal of the electoral commissioner, be sure that even if there is some basis for the petition, most likely others will say, didn't we say that there was already an agenda to remove this person? That's the context in which I'm saying I wear my legal hat and say, President has done nothing wrong, but then I also have my political hat and my experience in government and saying that maybe he could have done things differently. But I can't fault him.
Yeah,
for doing what he has
done. I suggest to you that you're saying the president should engage in unconstitutional act and open himself to even suits, because those who sent the petition made it public. So it was public knowledge that a petition has been sent. So if the president didn't work to forward it, he was, opening himself up for, a suit.
Yeah, I perfectly agree with you that those who petitioned made it public, so perhaps the president's hands were tied.
Or maybe you can't, because you can't sue the president qua president.
No, not really.
You can take advantage of that.
Not really. Not really. The president is accountable to all of us as members of the public.
Right.
So if somebody sends him a petition and makes it public, his hands are tied.
Okay.
So that's why I'm reluctant to find faults whatsoever.
All right. So address the matters arising.
But then I just also want to say that being in government and knowing how things work, instigating things and structuring them in such a way that our hands are tied are all possibilities in the running of public affairs. But let me just say on record that the president has done nothing wrong. We may have discussions, we may interpret facts, we may say that maybe there are alternatives, we may examine the alternatives and then see the limitations of those alternatives. But so far the president hasn't done anything.
So matters arising. He
now
says writing to the presidency was wrong and all, and that if she gets to the committee and she needs these documents, they'll be given to her anyway.
I think I agree with that position, that the people who communicated to Charlotte and her lawyers that a matter has been referred to them for investigation will be the Chief Justice or her committee. So strictly speaking, they are the people from whom you should be requesting the particulars of what the petition contains.
Two letters, one to the CJ and one to the president.
So I think that the letter to the CJ is very appropriate, because I am told that the CJ, when she first received the petition, wrote to Charlotte so that she can have some response from her, based on which she can determine whether there is some prima facie case for setting up a committee. So at that point, when she wrote to them, I believe that it is a strategic point at which to also request for the details of the petition.
The content of the petition had been made known to her. A copy of the petition had not been given.
Yes, and I'm told that some excerpts from the petition was communicated to her, but the entire petition, including who the petitioners were and etc., were not presented to them. And I think that what the lawyers are asking for, and this is subject to correction because I don't have the details, but these are all things that we hear. I think what the lawyers are now asking for is for the full details, including portions that may not directly relate to Charlotte, including the particulars and the identity of who the petitioners are. I think that is what
they appeared before the committee, and that first day they were told there were two petitioners. They were drivers of the Electoral Commission against her. So, if you like, she knows who the petitioners are already. I mean, isn't that so?
That is now, but I don't know when they wrote the letter.
Forcing Akufo and Godwin Kujo or something like that. Godwin Gosway Dajo.
Yes, I'm saying that I don't know at what point they wrote making that request. Whether it was after they then went
on that day.
On that, yes. So that means that at the point when they were going to the committee, they didn't know. So they carried their letter, and before the committee, they made that request. I assume, from what I think a lawyer would do, that is what would have happened. So they wouldn't have done anything wrong by making that request. They still are entitled to the full details because it helps in making the case. And you see, when people talk about inappropriateness, and when people begin to suspect foul play and etc., there are certain things. For instance, if I got the full details of the petition, there are certain claims, certain issues raised in the petition that the first question I'll ask myself as a lawyer is a driver likely to know this in an organization? Is a driver likely to know about when procurement is being done, what documentation has taken place in relation to...
Does that matter if they get to know
it doesn't matter.
Okay.
But I'm asking. It doesn't matter. But I'm asking, is a driver likely to know about procurement issues in an organization as complex, big, huge, and
provide all those
as
details
the Electoral Commission, and provide all details in relation to the procurement?
Could that not be why the drivers or the petitioners are using counsel? Because when someone comes to you and they say, I want to file a petition,
yes,
you, the lawyer, you make demands of them.
Yes.
Bring this, bring that, bring that.
Yeah.
So if they're able to seize documents or get documents and bring to you, you'll be able to detail it properly. So drivers are capable.
I'm not saying drivers are incapable. It depends on the level of education of the driver. Depends on the level of involvement of driver in administrative matters in the organization,
and the kinds of conversations
whether the driver is just driving or driving and listening to conversations. But the question I'm asking myself is, as part of the work of a lawyer, one of the things that he will seek to do is to establish whether or not indeed this petition is coming from the driver. And as part of the political conversations that we're having, about really where is the instigation coming from? Is it a grand scheme or is this an ordinary petty matter? If it's a grand scheme, then one of the issues that we really have to provide answers to is how a driver got access to this level of information, which could see chairperson of...
You're just being reminded that drivers eavesdrop on so much, and if you have forgotten,
it is one of the...
Victoria Hammer, right?
I'm saying that
it is a driver who got out of that job as a deputy communications minister.
Yeah, it is reasonable that a driver would record, and once we get the tip, that's a very simple matter. But a driver will listen to conversation about the procurement and indeed be the one to do the petition.
The driver could be asked to go and make photocopies, and they will keep copies.
Driver is possible. So many things are possible. Let me conclude on that matter. So for me, that is a very, let's not trivialize it. That's a very important.
No, this matter will take a lot of our attention, so don't worry, hold on.
So the last bit of it, about the process, I believe that we should all follow the process. I believe that we should be mindful not to bastardize institutions. I listen and I see people attacking institutions who are just doing their jobs, like the president doing his job, like the Chief Justice doing her job. Let's be mindful. We're a country that believes in the rule of law. We have a constitution. The constitution details the do's and don'ts. So the yardstick should be in the constitution.
But it's not. It should not be seen as an attack. If the Chief Justice says, I have made a prima facie determination, and the respondent feels the determination has been made in a vacuum, there is no documentation backing how that was done, as precedent will show, that is not bastardizing an institution. To ask that, where's the record that shows that this is what has happened? That's not bastardizing an institution. So people should have the right to ask the questions that they ought to ask, even though it's an in-camera process. If some of it gets out there because it involves public officers, very sensitive officers like the Electoral Commission.
I mean, you can ask questions without a language that bastardizes institutions. I mean, I still think, and I've raised this issue, that given the sensitivity of the issues involved, maybe this is the point when we should begin to think about having clear rules governing how these kind of processes undertaken.
Okay.
And then also that we might want to inject some level of transparency, even though the proceedings are in camera. If there's room to open it up so that the public can follow, the media can follow. One of the things that made something like the decision of the Supreme Court in this election petition acceptable was because every Ghanaian was monitoring the process. They were watching. And so by the time you gave your ruling, people had decided that, well, this is what it should be. So they easily accept it.
Well, that one, the Constitution did not, circumscribe that you cannot have it TV cameras in the court. So that was possible. In this case, the Constitution is very clear, categorical, that this ought to be conducted in confidence. Kweku, is it also, for example, he has suggested some of it, but is it also bastardizing or asking unnecessary questions of institutions when the question arises that the issues that prima facie have been made on are basically procurement issues? And the question is, did the Constitution contemplate that procurement issues will form the basis of what the Constitution calls stated misbehavior, incompetence, or inability to perform your functions by virtue of infirmity of the mind or body?
Well, I'm not a lawyer. I'm just a layman. But clearly the third one is completely eliminated. The list you just gave, I think that is out.
That's infirmity of mind or body.
And the second, I'm coming from the top,
right.
from below. The second one was, if you remind me quickly, competence. Incompetence.
Yeah.
And then, well, that's the first. Directly you don't hear procurement there, but depends on how the procurement is done. And assuming it has some criminal connotations, then perhaps, and I'm talking as a layman, so maybe we'll have to look at the extent of the incompetence or criminality that may go into number one and number two. I'll leave that to people who have the
number one is stated misbehavior, number two is competence.
I have a difficulty even with the number one.
And we are referring to the constitutional provision which gives you basis to file a petition. The petition must contain some content, and the content ought to be that it is challenging the competence of the person to perform their functions, that they are not able to perform it, or that they have they have misbehaved, stated misbehavior, and or that they are so ill or they have a mental incapacity that they can't continue to do their job.
Yes, and I'll be surprised if our courts have not dealt with some of these things in terms of the first and two. Maybe we have to double check it. But on the surface, mere procurement, I think, wouldn't be captured. But I think depends on what goes into that procurement and how it impacts.
Maybe if you got a kickback out of the procurement.
Yes, that should be serious. That should be a serious matter.
Should be stated misbehavior.
That's right, in my candid opinion. But before I proceed further, I want to clear one or two things. And my brother, Andrew, was talking about transfer from NCC to
Electoral Commission.
Yes, I think I found it curious. It doesn't have to apply here at all.
Why?
Because if you look at the details, the evidence, and don't forget, this is one of the cases that was sent to it's part of the 37, and I'm not surprised that it was thrown into the dustbin of history. The lady resigned her position before she received the instrument of appointment. She resigned on 29th of June, 2015, before she became effectively the new UC boss. So there's no question of transfer. And she resigned voluntarily after an announcement had been made that she's heading towards this place.
I'm not sure he's saying he's unaware of that.
Yeah, but so
he's speaking about something that has been obviously engineered.
Oh, please.
If the president says you are in NCC, I want you here, so you resign today, tomorrow I'll give you this job. What happened?
No. If the president says I'm appointing you to institution B, and you are in institution C, they are all creatures of the Constitution.
Right.
Are you telling me that that was done under duress? You are inviting us into the realm of speculation.
Okay.
And I think that's unfair. You must stick to the facts. The facts are that she received the instrument of appointment on the 30th of June. The day before, she had resigned. So and that is why I'm not surprised it was thrown away.
Okay.
And in terms of the law, there's no basis for anybody
So
to
proceed
talk
to the matters
transfer.
arising.
Then
after
another one.
Prima facie.
Look, if indeed President Mills received a petition, so-called, relative to Madame Georgina Wood, and did not act on it, he committed an unconstitutionality. It's as simple as that. So I don't see how people are recollecting that today as perhaps a best practice for another president to follow. It shouldn't be raised at all. Indeed, I think it doesn't help the dignity of President Mills, who we all knew was a lawyer of high repute. So let's throw that one to outside the table.
Maybe a second.
Yes, please.
Where in the Mr. Abuchi, where the question is about receiving a petition for the removal of the Chief Justice, then there would not have been a requirement for the petition to be forwarded to
anybody.
the same Chief Justice.
Sure.
Clause 6 says that where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State,
Thank you,
appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. But Ejechum would say that prima facie also had to be done before the process continues, right?
Absolutely. But
so who is going to do that?
Is it not the
Who's
committee?
going to do the prima facie?
I thought it's the committee.
Correct. That would
Great.
establish that.
Thank you.
But I still hear something.
Okay.
So good education for you.
Yeah.
It's not the same.
And now, you see, the letter inviting the respondents, I suspect, and I'm assuming safely, that the 3 received the same letter in terms of wording. I don't know, you have to guide me, and indeed the 4 of you are lawyers, because the letter that was initially sent to the respondents, inviting them for their responses to the allegations contained in the petition, the Chief Justice indicated that this is on basis of strict confidentiality, and that if any of them were to breach it, they would suffer contempt, the consequences of contempt. Now, I'm not part of the respondents, obviously, but I still need guidance. The letter that was sent to, you know, we journalists, we intercept. So that's why I'm asking for guidance, whether reading from this letter will create problems for you, not exactly for me. I don't care what the consequences will be.
It's about the parties who make the disclosure.
Thank you. See, this is a letter dated 6th December 2017. It's invitation to appear before the committee. Petition brought under Article 146 of the Constitution of Ghana for the removal from office of Mrs. Charlotte Osei, Chairperson of the Electoral Commission. Please be informed that the Honorable Lady Chief Justice, has set up a committee in accordance with Article 1463. I have a difficulty here. Because when I checked what happened in the case of Loretta Lamptey, let me read the first paragraph. It says, I have been directed, this is coming from Justice Alex B. Poku-Achampo, Judicial Secretary.
Right.
This was dated 2nd December 2014. It says, I've been directed by the Honorable Lady Chief Justice to refer to your client's petition dated 30th September 2014 to His Excellency the President of the Republic of Ghana, John Dramani Mahama, pursuant to Article 1463 for the removal from office of Ms. Loretta Vivian Lamptey, Commissioner for Human Rights and Administrative Justice. After studying the said petition and the response to it by Ms. Loretta Vivian Lamptey, the Honorable Lady Chief Justice has decided that a prima facie case has been established against the Commissioner. The Honorable Lady Chief Justice, in compliance with Article 1464 of the 1992 Constitution, is therefore in the process of setting up a committee to investigate the complaint, find attached the report by the Honorable Chief Justice on the petition. Then a letter was subsequently sent where the names of the committee members were put. And this one, it says, we write to inform you that the Honorable Lady Chief Justice, in compliance with Article 1464 of the 1992 Constitution, has set up a committee made up of the underlisted persons to investigate the complaints. Then they are listed.
Okay.
Now, the difficulty I have here is that, and unless this was an inadvertent omission, the committee that they appeared before, which is the committee to investigate the matter, subsequent to the prima facie determination, we are being told was set up under 1463. That's why I say you are the lawyers.
This is what 1463 says.
Yeah.
I'll just read it. 1463 says, if the president receives a petition for the removal of justice of a superior court other than the chief justice, or for the removal of the chairman of a regional tribunal, he shall refer the petition to the chief justice, who shall determine whether there is a prima facie case.
That is 1463. So I see a difference here. I see a deficit. So it's when the respondents appeared before the committee that they were informed that a prima facie determination had been made, and that this committee is the one to deal with the issue subsequently. I said there's a defect
Your
there.
point is that instead of referring to 1463, they should have been referring to 1464.
Yes.
1464 says, where the Chief Justice decides that there is a prima facie case, he shall set up a committee consisting of blah, blah, blah.
Yes. I see. You see, I'm looking at a situation where a more tidy precedent had been laid down. I'm not going to force somebody's precedent on everybody, but I think that we've been growing our democracy. And I see the...
But that's not fatal, is it?
It's not fatal at all.
To quote 1463 instead of 1464.
It's not fatal at all.
Okay.
But for the respondents, they will have every right. They are entitled to raise all those issues. So you make the process neat and clean.
Okay.
That's all I'm saying. To be honest with you, as far as I'm concerned, in substance, the focus should be on the due process that have been unleashed. Right. But procedural fairness is also critical. I'm not looking at the substance now.
Okay.
But it's important that these things are done. Look, for instance, again, in the Loretta Lamte thing, as I've said, the list of the membership communicated to the respondents and the petitioner. In this case, they had to get there to see those who constitute the membership. And there was the decision not to even do formal introduction. Perhaps are still part of the confidentiality thing. I don't get it. And if you didn't know all of them...
The confidentiality thing, and about when we get that, you should help us. Should the confidentiality thing not be about the hearing itself?
I thought so.
Rather than things like the membership of the committee?
Yeah, you're asking about...
Yes,
yeah,
yes.
Yeah. Sir.
Well, first of all, I'm not a Supreme Court, so I can just give my opinion just like everybody else. I must say that, taking a cue from Kuku, and he warned us about something, but still invited us to the minefield. And so we're going to stay clear of that. The requirement of in-camera and confidentiality hearing requires all of us to also respect certain levels of confidentiality, especially the legal professional component, to avoid unnecessary disclosures. But he is clearly out of that, and he's in a different business, and so I can understand why he can have access to things and speak to things we can't.
When I conducted the Shraj matter, not one word was heard on radio.
Right.
In fact, the members thought, okay, this guy is a lawyer, he's also a journalist. He'll reveal things. They were shocked. Not one thing got out of the public.
Right. We have professional ethics to respect, and it's important for us to respect that while this is not a purely judicial proceeding, it's quasi-judicial in character.
Thank you.
However, the Constitution is clear on the fact that it has to be held in camera. The policy rationale for that is to ensure that there's a degree of confidentiality and that public expectations and the rumor mongering is managed. Because if you're not careful, people will be convicted even when in fact they're innocent. And in the process, the outcome may not matter much once people just go on a rampage.
So the question briefly before we get to you substantively is, the issues to be in confidentiality, should they include the membership of the committee?
Well, the question is not what is included in or out of the range of spectrum of confidentiality. The question is, to whom should it be confidential? It is confidential, or should be, or could be confidential to the rest of the public. In fact, the entire proceeding could be completely out of the picture for the rest of the public. So even who is a member of the committee, you and I may not know, and it's fine. But for the persons whose rights are in issue, they're entitled to know everything about the proceeding. So the proceedings are supposed to be fully transparent to the people who are involved, which include the persons against whom accusations have been made. But for the rest of us, we can be kept
Samson read the names of the members of the committee because they were out there, even before the respondents appeared.
Which is funny.
You can't hide it. No matter what they do, that they cannot do anything.
But the point I'm making is, assuming that one has been kept secret from the rest of us, assuming we know nothing about anything happening, it is totally okay to the extent that the parties and their lawyers involved have disclosures as far as these things are concerned. So for the parties involved, there's absolute transparency and openness. But for the rest of us, we can be kept to the dark.
See, for example, why it may be near impossible to have confidentiality of the committee composition. Again, the only experience I have, and a rare privilege, is the Shraj matter I conducted. The judges, Justice Eninyebua, who is a chairperson, had to write letters to the courts where we, the lawyers, had cases, because the Chief Justice had ordered that we should conduct the case expeditiously, and therefore they set aside 3 days every week that we're supposed to attend to them. Meanwhile, we are lawyers and we have a business and we have clients, we are supposed to attend to their cases in other courts. So they had to write and ask the other courts to excuse us. What it means is that the letters got to the other judges, the cases will come, the judges will let them know, or the other lawyers and the parties involved, that you can't have Samson or Sevo in the court for this matter on these days because they are at this place. So it's difficult.
The point I'm making is, as to the practical difficulty or otherwise, we can discuss it separately.
Okay.
But what I'm saying is, assuming that the whole process can be kept confidential, assuming that the appointing authority, which is the Chief Justice, assuming that the appointed people who are the members of the committee, assuming that the parties involved, assuming that the lawyers involved, and other transcribers and other secretarial support and all that, assuming they can all respect the oath of secrecy and confidentiality, assuming, then in principle, we may actually be potentially kept in the dark. And I'm saying, should that happen, that is okay. The Constitution says in camera means for the rest of us who are outside, we're out.
Okay.
So we can be kept in the dark and we can continue speculating and saying all kinds of things. But for the parties involved, the principle of confidentiality and the principle of in-camera hearing doesn't apply to them.
Thank you.
Yes, interestingly, walls have ears and they speak. And indeed, as indicated, Samson read out the list. But when the respondents appeared, there were 2 persons whose identity they wanted to know. And they were told the identities could not be disclosed for national security considerations. That's a fact. Okay? Now, I am saying that this is in contrast. Maybe it's a different style, fine. But I find the earlier precedent, the Human Rights Commission one, a better practice to follow. Listen, again, the respondents got to know of a determination of a prima facie case a week before they received the letter which didn't even tell them prima facie had been established. They had to go to the committee for them to be informed that a prima facie case had already been established, and that's why this committee has been set up.
Really?
Oh, yes. Okay? And all these breaches were happening weeks before the committee invited them to appear. It doesn't help. It's not a tidy process, as far as I'm concerned. But I agree, it doesn't touch on the substance yet, in my candid opinion. The candid opinion, the substance is that now you are being told that 21, and you see again, when you say this, you are not even too sure whether the 21 cases that have been dismissed was dismissed against all the respondents. That's another area we don't know. 6 cases stand in the name of 2 petitioners, 2 drivers. I have no problem with their occupation or vocation or whatever it is. But it's
allegations.
Yes, but it's interesting to know that our friends who are making a lot of noise, they know the drivers. One of them is part of their party. Oh yes.
How?
This is a mischievous input.
How?
I'm telling you, it's well known. Is it
Gosway?
Yes, he's a member of your party or an activist. Indeed, he had rental problems recently. You people footed the bill for him. So I'm only cautioning you. I'm cautioning you guys to leave politics, this partisan politics, out of it.
Okay.
Honestly, it is not helping anybody, including the respondents.
Oh, but is that not what
Here's a situation where you've done well. Let me be honest, but I'm making a general point. The respondents are interested, or let me say, as far as I know, Mr. Charlotte say, is focused on dealing with the issue within the context of due process. And that is why she wrote a letter to the Chief Justice, the Judicial Service, asking for copies of the petition and also the basis for prima facie. Also, as written, as far as my sources tell me, a letter now addressed to the CJ herself on same principles of asking for some information, the full list of the petitioners and all the rest. Now, don't forget, the petitioners have moved from 17 to 2. It was first faceless and nameless, but that mischief was cured before the president forwarded the petition. The lawyer subsequently went, dated the petition.
How did he cure that mischief?
The first petition that went to the presidency, the same one which was sent to Yuoko, was undated and unsigned. That was not forwarded. What was forwarded was you brought name, yes, 17, take it from me.
And their names were there.
Take it from me. And that is why, that's why you may understand why a letter went to the presidency for some tactical reasons. But 17 now have become 2. Somebody said the 2 are representing the other 15. It is not true. There's nothing like any evidence of power of attorney or any delegation to the 2 that represent the 15. In any case, it's not even a good practice. If you've signed a petition under Article 1463 and the 1464 has been triggered, I don't see how you say you've delegated your responsibility to somebody else. But you see, Samson, driver or no driver is immaterial. It is when cross-examination comes that we will see that this man who is making the allegation, who is the petitioner, has the capability, or it could be a driver, but a very wise, intelligent, and educated one,
Right.
and could marshal the enough evidence to deal with the case. But it is through the cross-examination.
Okay. We have a couple of questions to ask. I can see you have a lot to deal with, and it does appear there are people who have followed you on this and have been itching to hear you. So good, they have heard you partly now.
Sure.
We would return to this because this issue takes a great part of our discussion this morning. Now, you teach us constitutional law. And beyond that, now you've written a huge book for us to benefit from as far as constitutional law is concerned. First of all, if we could move on to the letter as written by the respondents, one of the respondents, because there are 3. Even though there are 3, there are 2 separate petitions. That's what we understand. One petition against Charlotte Osei, the chairperson, and another petition against the other 2 deputies. We seem to pay a lot of attention to the one against Charlotte Osei because that is the one that started first, and it is the one that some information has come out now about what happened at the level of the prima facie. When she writes to the president asking for a copy, because she doesn't have a copy as at that date, the 11th of December, was she in any right to do so? When she writes almost the same letter, but a little bit extensive, to the Judicial Service, requesting that she should be furnished with the petition because she hasn't seen it. Has she got the right to ask for that? Has she got the right to ask that the committee should be named? Has she got the right also to ask that she wants to know the basis of the determination of the prima facie? And finally, has she got the right to ask for the terms of reference for that committee?
Starting with the letter, asking the presidency to produce the letter for you is asking someone to give you what the person doesn't have officially. The presidency's position as far as petitions are concerned, generally speaking, is very ministerial and very perfunctory.
Perfunctory.
Right. The president doesn't really play a substantive role, or the presidency doesn't play a substantive role in the entire removal process. The presidency only receives the petition and then receives the conclusion of the process and then acts on that. So after receiving the petition, once the president complies with the constitutional requirements of forwarding to the Chief Justice, the president doesn't officially have the petition. Yeah. What should have properly happened, in my opinion, respectfully, to the committee, and again, I don't claim to know what's happening in the committee, but again, speaking from everything else that has been reported,
we're all speaking from what has been reported in the media.
So speaking from what has been reported out there, what ordinarily one would have expected to have happened would have been that once the committee is set up, the committee should have done all the communication with the respondents. Now, part of the communication, this is a quasi-judicial process, and therefore a quasi-judicial process combines aspects of judicial proceedings and regular administrative proceedings. So in its administrative aspect, normally committees like this, once they are writing to you, invariably attach if it's a petition, if it's an accusation, if it's a complaint, if it's whatever it is that have been made against you, they normally attach a copy to the letter that is written to you.
That's my experience.
And actually invite you to forward your response. And that's the beginning of the process before hearings formally commence. So ordinarily, my expectation was maybe this should have been done. And again, I have no idea whether it was done, but from the reportage, it doesn't seem...
From her letter, it was not done.
It doesn't seem it was done. But asking the presidency was just the wrong place, because the presidency at that moment has been rendered what lawyers will call functus officio. The presidency has been discharged of that letter. The presidency has been discharged of its functions, and therefore they were not even in a position to produce anything. In fact, if the presidency had produced something like a petition to him, even if they have a copy, the presidency would have just produced an alleged document. A document which frankly will amount to nothing. And she couldn't even possibly code for moving forward. So asking the presidency was just the procedural difficulty there. I think the proper place that such a request ought to have been directed would have been the committee. And that ties in then with the question of whether she's entitled to know who the committee members are, etc. Again, ordinarily, the expectation is yes. Let's face it, even though Siraj's investigative process represents a good precedent, we are still very much in our elementary stages, and these proceedings are a bit novel. The novelty of these proceedings are partly reflected in the fact that we don't have developed rules in terms of what the methodology of the findings are going to be. If the committee decides to sit, how are they actually going to go about this? Are there going to be regular evidence, hearings, and the regular processes of judicial proceedings, or are they going to go by mainstream investigative proceedings?
What we understand is this: they would file witness statements, like it is done in the civil process. In the Siraj boss matter, at that time we had not introduced the witness statement, so the petitioner steps in the box, and then he's led in examination in chief by his counsel. Then the other respondent's lawyer cross-examines the petitioner. When the petitioner is done, the committee members may have questions. They will ask them. Then the respondent will also step in the box. His lawyer or her lawyer will lead her through a examination in chief. Then lawyer for petitioner will also cross-examine her. And then the committee will also ask their questions. And then when the process is over, in the Siraj case, they asked that we bring addresses. So we wrote addresses before they did their decision.
It's good to know, and thanks for the details. So there is some methodology stated out there, some procedural methodology within the committee stated out there. But back to the question of whether she's entitled to know one thing or the other, she's entitled to know everything. And that's the point I stated earlier.
We'll take a break. When we come, I'll take you to the letter point by point, and you state where she's entitled and where she may not be entitled. We'll be right back. This is Newsfile.